Good evening. I am here today with Minister of Justice and Attorney General David Lametti and joined online virtually by the Minister of Indigenous Services, Patty Hajdu. Kwekwe ulukut, tanse, hello et bonjour. Je tiens à souligner d'abord que je m'adresse à vous aujourd'hui depuis le territoire traditionnel du peuple Anishinaabe-Algonquin. Le Canada, la Société de soutien à la famille et à l'enfance des Premières Nations et l'Assemblée des Premières Nations ont convenu de suspendre les procédures relatives à la décision du Tribunal canadien des droits de la personne. L'accent, aujourd'hui et dès lundi, sera mis sur la conclusion d'une entente à l'extérieur du tribunal et à la table de négociation. We're committed to dropping the appeal upon reaching a global resolution of the tribunal orders, class actions, and crucially on long-term reform. This decision was made with a mutual understanding. First Nations children deserve and must be compensated. Canada chose to file a notice of appeal today because we are concerned about imposing a one-size-fits-all approach. We've said this before. Know that it is our steadfast goal to reach an agreement outside the courtroom, as asked by Judge Favell, and get to the right outcome at the negotiation table by talking. There's work to be done outside the courts. Long-term reform, self-determination discussions. This is what we will be doing moving forward starting Monday. Il incombe au Canada de réparer les torts du passé et de mettre fin au racisme et à la discrimination continue à l'égard des peuples autochtones. Nous continuerons de travailler avec nos partenaires provinciaux et territoriaux, ainsi qu'avec tous les Canadiens pour lutter ensemble contre le racisme à tous les niveaux, dans tous les secteurs de notre société. Les enfants et les jeunes autochtones sont au cœur de ce que nous faisons et nous demeurons déterminés à améliorer leur santé et leur bien-être. C'est une partie essentielle de notre cheminement vers la réconciliation. Miigwech, Yanamik, merci Cho. Thank you. Now I'll pass the microphone to Minister Hajdu.
Thank you very much, Mark, and thanks to everyone for joining us today. I'm with all of you virtually, but physically on the traditional territory of the Fort William First Nation. This past few months, Canadians have been starkly reminded of the experiences that Indigenous families and communities have lived and continue to live today. And for First Nations people, this was not a surprise, and it doesn't make it any less painful. And we have to support communities and families so that they can continue their healing journey. I believe this is on the hearts and minds of all Canadians. We also know that fixing a broken system requires long-term reforms. The Government of Canada is determined to eliminate discriminatory policies and practices against Indigenous children, and we are doing it hand in hand with Indigenous partners. Since the Canadian Human Rights Tribunal issued its first order for Canada to cease its discriminatory practices in 2016, we've been working with First Nations leaders and partners to implement the tribunal's orders. And we've been unequivocal. We will compensate those harmed by discriminatory underfunding of the First Nations Child and Family Program so that we can mend these past wrongs. Today, the Government of Canada, the First Nations Child and Family Caring Society, and the Assembly of First Nations agreed to sit down immediately together and work towards reaching a global resolution outside of court. Through this process, we're making sure that those who were harmed are fairly compensated. And we're also committing to significant investment to address the long-term reform of the First Nations Child and Family Services. We want to make sure that no more children are harmed, that we end the discrimination. We will work with the parties to put in place an approach that will best serve these children. And this means that while Canada filed what's known as a protective appeal of the federal court decision of September 29, 2021, the appeal will be on hold. And all parties have agreed that we will focus squarely on reaching an agreement outside of court and at the table. A significant offer is indicative of our sincere desire to reach this resolution of the tribunal orders, class actions, and to take action on that long-term reform that's so overdue. The government is committed to compensating people harmed by discrimination and to end that discrimination by ensuring that First Nations children have access to necessary supports and services. I want to personally thank all of the parties who have worked so closely with me and the other ministers over the past week to get this agreement to pause the appeal in place. We're looking forward to renewed focus together with one goal in mind, the wellness and the rights of First Nations children. Miigwech, thank you, and merci.
Thank you. We'll now take questions from journalists. One question, one follow-up. We will start with questions from the room. Go ahead.
Hi, Minister. Stephanie Taylor with the Canadian Press. Thanks for making time this late Friday. The tribunal was quite clear that First Nations children and their families are entitled to $40,000 each. Your government has that money. So why make people wait and create another process when you could just give them the $40,000 the tribunal says they are owed?
Well, I think that's a question that's been posed often, and it's a good question. I don't think there is any intention to want to reduce any amounts paid to remove children. We have said from the get-go that we want to compensate those children. This is a broad and sweeping decision by the Canadian Human Rights Tribunal, and we continue, and we've said it before, to have certain jurisdictional issues with it. That should not prevent us from moving forward on a global resolution. Now, let me just be crystal clear about this, Stephanie. We could implement the orders as written tomorrow. One, it would not fix the system which continues to be broken. It would advance very little on long-term reform. Two, the other class actions that would purport to compensate other peoples, other classes of children that have suffered equally, if not worse harm, would not get compensated. There are interlocking issues, sometimes children represented in theory by 3 different counsel. So we are juggling very, very complex legal files, and when people lawyer up, people get dug in. So what we're doing today, as opposed to the past, is filing a notice of appeal. But what we're not doing as a government is spending time and energy taking adversarial positions. We're saying to the parties, and we thank them for the work that they've done, is we're putting a very significant financial package forward to do 2 things: to compensate children that have suffered that harm over a broad period of time, and to move forward on something that is so crucial so that we're not reproducing the broken model that got us into this position in the first place and going back into litigation 3, 4, 5 years from now. That is a substantial offer, and it's something that we're going to work on starting Monday morning. We're going to put resources into doing what Judge Favell asked us to do, is walk the road of reconciliation, sitting down and hashing this out among mature peoples. And that's what we're doing. It's a question of respect, and it's a question of fairness. Now, out of that same fairness and out of respect for the parties, we can't discuss the financial package that's been put forward. We know, and Indigenous peoples know, that to fix this problem, it's going to cost billions of dollars. We can't shy away from that fact. And Canadians that are watching here today should know that this is a broken system. People have suffered harm. It was unfair, and it needs to be compensated, and that's what we're saying today. So this is a radical departure from the past. People can complain about the appeal that was filed today. We fully understand it. No one wants to be in a position to appeal. But depending on how those discussions go, we're very much prepared to remove it.
Thanks for that, Minister. You say the intention is not to reduce the compensation for First Nations children and their families, but can you commit that those First Nations children and families will receive $40,000 each, as the tribunal says they should?
Again, this is a process that starts Monday. We have undertaken, to the Caring Society foremost, the Assembly of First Nations, to keep those discussions private. There are 2 other class actions that are present as part of that discussion. Out of respect, first and foremost, for the children that you're referencing, there is a lot of work to do, and the worst thing we can do is raise those expectations of an immediate payout of substantial sums, but know that we're working towards that.
Next question.
And maybe
Bonjour, Monsieur Miller, Louis Blouin de Radio-Canada.
Je pense que la ministre Hajdu avait quelque chose à rajouter.
I just wanted to add to that. To be perfectly clear. All parties agreed to keep the details of the negotiations private and confidential until we have a deal. It's an extremely important element of the agreement by all the parties. And I do want to thank again the parties for agreeing to this hard work, because of course we've spent the last week getting to this place together, but the real work begins on Monday when we sit down and we work out the many details such as you're asking. But I will say in particular, I know that the parties have worked over the last several days to get to this place of comfort with the sincerity of the intent of the federal government. And of course, the significant offering that we've made has demonstrated to them that this is a sincere intent by the government of Canada to ensure that compensation is in place and that this system is reformed.
Bonjour, M. Miller, Louis Blouin de Radio-Canada. Le fait est que vous avez interjeté appel aujourd'hui. Vous dites que vous voulez négocier. Quand on regarde ça de l'extérieur depuis le début, on a l'impression que la seule intention du gouvernement, c'est de vouloir verser moins aux enfants qui ont subi un préjudice. Ma question, elle est simple. Pourquoi placer l'argent avant la réconciliation?
Ben, je vous dirais, Louis, c'est tout à fait l'inverse. Ce qu'on a essayé de faire depuis tout le début et ce qu'on a dit très clairement, c'est qu'on allait compenser ces enfants pour le tort qu'ils ont subi au cours d'une période de plusieurs décennies dans certains cas. Sachez qu'il y a trois arrêts. Il y a l'arrêt du tribunal des droits de la personne. Il y a deux autres procédés légaux qui se chevauchent, qui ont attrait, dans certains cas, aux mêmes enfants. Donc, il y a une certaine complexité avec laquelle nous composons. La juridiction de la Cour du tribunal qu'on questionne a un seuil maximal de 40 000 $ de compensation. On sait qu'il y a des enfants qui ont eu et ont subi des préjudices qui vont au-delà de ce tort. Alors, dans la mesure où il y a plusieurs arrêts qui se chevauchent ou plusieurs motions devant le tribunal qui se chevauchent, il y a une question d'équité dans tout ça. Alors, ce qu'on fait aujourd'hui, c'est qu'on dit à toutes les parties concernées, qui ont tous des avocats très sophistiqués, c'est mettons ça de côté, asseyons-nous à la table, faisons ce que le juge Favel nous a dit de faire, c'est-à-dire d'entamer des discussions et d'en venir à une solution qui va être équitable pour tous. Ça implique deux choses. Une formule de compensation qui ne retraumatise pas les personnes en question parce que ce n'est pas seulement une question d'argent. Et un autre volet, tous les deux avec des composants très importants de compensation financière et d'investissement à long terme pour en finir avec ce système qui cause préjudice aux enfants autochtones. C'est le cas toujours aujourd'hui qu'il y a 50% des enfants qui sont dans le service de garde qui sont autochtones. Et pourtant, ils ne forment que 5 à 7% de la population en général. Ce n'est pas juste et c'est ce que nous allons faire avec les parties qui sont concernées. Alors, les gens diront depuis le début qu'on est plus concerné par l'argent. C'est nullement le cas. L'ordonnance de payer, puis si les gens contestent ce fait, c'est parce qu'ils n'ont pas lu le jugement du juge Favel, il est sorti cette année. Ça n'a pas sorti en 2007, ça n'a pas sorti en 2016, c'est sorti cette année. On a accéléré le processus pour en venir avec une décision de la Cour fédérale. Alors, ce qu'on a fait au gouvernement fédéral, c'est d'accélérer le processus pour en venir à une certaine finalité. Il y a des éléments de juridiction que l'on conteste toujours, mais ça ne nous empêche pas d'aller de l'avant dans un esprit de conciliation avec une offre financière qui va rester confidentielle, évidemment, pour en venir à cette discussion. Et sachez que les autres parties ont dit oui, évidemment, pour qu'on ne soit pas dans les prochaines semaines à prendre des positions qui sont opposées devant la Cour, mais vraiment de se parler entre nous puis de régler le compte une fois pour de bon.
Aidez-moi à comprendre, autour du 40 000 $, en quoi le traumatisme d'un enfant qui aurait passé, supposons, quelques semaines dans le système d'aide à l'enfance serait différent d'un autre enfant qui aurait passé quelques mois dans le système d'aide à l'enfance? Est-ce que son traumatisme à lui vaut moins, ne mériterait-il pas ce 40 000 $?
Écoutez, Louis, c'est des sujets qui sont immensément pénibles pour les enfants en question, surtout, qui vivent les séquelles des traumatismes des services de garde à l'enfance. C'est clair qu'une personne qui passe une journée qui a été de façon injustifiée enlevée de sa famille suite à la discrimination a subi un préjudice. On sait, avec toutes les études qui sont faites sur tous les traumatismes que puissent être infligés aux enfants autochtones, durant cette période allongée de garde, se multiplient, d'aller de famille en famille. Des enfants qui ont été battus, qui ont été violés. C'est exécrable, ce comportement, puis on le sait. Et d'une certaine façon, l'argent ne peut pas nécessairement remplacer ce tort qui va être subi à long terme pendant toute la vie de la personne. Mais on parle aujourd'hui de régler le système. Et ça prend cette concertation, ça prend cette discussion, et c'est ce qu'on propose de faire. Ça fait depuis 2015 qu'on est au gouvernement en train de régler ce tort. Ça continue, et on veut le régler une fois pour toutes, et de simplement payer de façon d'un coup la décision du tribunal ne réglerait pas le système et le problème qui continue d'être brisé, ni de compenser ceux qui ont subi le pire préjudice durant des périodes qui peuvent s'allonger jusqu'à 20 ans. First, David, it's hard to quantify in monetary terms the lifelong prejudice that a child can suffer, an Indigenous child, from being removed from their family, from their culture, from their language. But that's the imperfect system we're facing, and trying to fix the harm that children have felt, and to the extent that money can compensate for it. The court found that the discrimination occurred and that the act of removal itself was subject to monetary compensation. We know that children that have spent a long time in care, whether it's 2 months, 2 years, 20 years, the more you're in care, the more risk you are at suffering physical, mental harm, including rape and beatings, moving from family to family, and the trauma that's related to that. There are children that are entitled to more than $40,000, and that's clear. This is something that it's probably hard for people to hear, but that's the reality of it. And those are why these discussions are so difficult. It's why they're so important in getting to a financial package that is fair and equitable, and then fixing the system that's broken, with 50% of Indigenous children in care only representing 7% of the population. It's something that we need to fix, and it's something our government has said we're going to fix. But we need the expertise of Dr. Blackstock. We need the expertise of the Assembly of First Nations. And we need to apply the reports that have been produced to us as to how to fix the system, and we know that it will cost a very large amount of money to get there. Minister Hajdu probably would like to add on that as well.
Well, I think, Marc, you've really summarized it well. I do think thanks are due to Dr. Blackstock, of course, all of the parties. But I had the opportunity to speak with Dr. Blackstock for the first time after being appointed, and it's obvious that she has come to this work from a very personal place, a lot of personal experience in her previous work, and obviously with her heart focused on stopping the harm. Compensation, of course, and the Government of Canada, as I said in my remarks, does not in any way quibble with the need to compensate, but also equally to make sure that this doesn't happen every day in an ongoing way to First Nations children around this country. I think Marc has been very eloquent in talking about the extent of the harms. I personally have worked previous to politics with and amongst Indigenous people who went through a particularly brutal process to receive reparations from residential school harms that was extremely invasive, re-traumatizing, and in no way would I want to be a party to a process that in any way re-victimizes people. So that will be part of the work of the global settlement, to understand and to put into place a program and a process that quickly gets resolution for people, but in a way that is compassionate and is respectful.
Next question before we turn to the phones.
Yeah, hi, Mr. Miller. Mackenzie Gray with CTV. You mentioned Cindy Blackstock. We were talking with her earlier, and one of the things she said throughout this whole case is that one thing she believes your government might be trying to do is pay some people who had, an easier ride per se, less money than $40,000, and some people more than $40,000. I've asked the Prime Minister, and you've been asked again. So can you just clearly state whether or not the floor for compensation is $40,000?
Mackenzie, as we've said before, we have put forward a significant financial package to fix the harm caused to Indigenous children, to First Nations children that have suffered at the hands of the healthcare system, at the Child and Family Service system, and its discriminatory impact on them. We have also put a significant financial package on the table to address long-term reform, so that we're not back here in a couple of years going through the same exercise, and children are traumatized by being removed from their homes. That is an important step for which we absolutely need Dr. Blackstock at the table. I understand her hesitation if I were in her position, and I don't think I ever could put myself in what she's gone through. The Canadian government spied on her, and that is something that would not inspire confidence in people like me sitting here today. But she has graciously opened her heart because she's fighting for First Nations children. And she will be at the table informing our decisions on long-term reform. So we fix this system. And that's key. The financial package is significant. I'm not going to go in detail for it because we need to be able to have a serious discussion about what the floor is, what the ceiling is for those who have suffered the most harm, and how that parses out between people that wouldn't necessarily be covered by the CHERT order, whether it's the $40,000 maximum or years that aren't comprised by the order. So there are issues of equity and fairness. There's no simple answer to the why don't you just pay it out argument, but people need to realize, and it's very important, that there are parties that would not be compensated fairly if we were simply to implement the orders in the way that they have been issued. There would be significant issues with other classes, as well as long-term reform, which is absolutely key to this discussion.
So it's up for discussion on the floor.
And if maybe I can jump in as well, Mackenzie, and it's nice to hear your voice. I'll say that the intent of the government is to make sure that people are fairly compensated. Dr. Blackstock knows that we share that interest, and I know that trust takes time to grow, but just the fact that we have all parties agreeing to pause this the appeal and to sit down together, starting immediately, to find a global solution should indicate to you that there is a serious commitment, financial commitment, on behalf of the Government of Canada to hopefully begin that process of rebuilding trust with the parties that have fought for and on behalf of First Nations people for a very long time.
So discussions will be ongoing about the floor, but I want to ask about the timing of this. This litigation's been going on for a while, and subsequently you lost the appeal a month ago. It's 6 o'clock or just 6:15 on a Friday. Why did you wait till the absolute last second to announce that you've come to an agreement, despite the fact that you're still appealing the case?
Oh, look, the discussions, it's no secret to anyone that putting together a financial package like that and looking at the best way to move forward is something that does take time. And it's something that we have been working with the parties over the last few days to do. And it's something that involves serious discussions, some backwards and forward discussions that I won't share with you. But it isn't slow playing things. And I think, one of the narratives that we've seen is this has been a slow play. It hasn't been at all. The order to pay came down this year. We moved expeditiously to appeal the issues that we had deep concerns with. The order was issued by the tribunal, and during the last 30 days, a good chunk of which was during caretaker, as the new cabinet is being formed. That does take some work to get going and to have concerted discussions with cabinet and the Prime Minister in moving forward in the way that where we are compensating and putting forward a package that makes sense in the spirit of what the judge at the federal court has said, which is getting our heads together and talking about it and working on what is key to this and was not included in the order, which is working on long-term reform.
Wonderful. We'll now just turn to the phones. Operator?
Thank you. Merci. Please press star 1 at this time if you have a question. Veuillez s'il vous plaît appuyer sur étoile 1 maintenant pour poser une question. Our first question is from Christy Kirkup from the Globe and Mail. Please go ahead.
Hi, good evening, ministers. In precise terms, what do you think can be achieved in talks between now and December with the parties that is substantially different than what the tribunal ordered and what the federal court upheld in terms of compensation?
Maybe I can start and turn to Marc. First of all, let me just say how grateful I am to have been able to talk to so many of the parties over the last 5 days to get to this place. Maybe it's 4 days, it's all a blur. And the willingness of the parties to, of course, with that significant offer, come back to the table with one sole focus, which is doing right by First Nations children. And of course, those people that have been harmed. That willingness means that complying with the court orders will result in a process that has been informed and indeed collaborated on with Indigenous people and with their representatives, so that the Government of Canada has a roadmap on how this should proceed, as I said, in a way that A, is respectful and not re-traumatizing, but also gets to those longer term reforms that Minister Miller has worked on and talked about for quite some time. That piece is equally important, and that piece is equally tricky, if not more, in my mind, because that's about ensuring that this doesn't happen again and again to any First Nations child, and that First Nations children, regardless of where they live, have the absolute best and equal opportunity to thrive. So maybe I can turn to you, Minister Miller, to talk a little bit more from your previous experience.
Yeah, well, anything that gets us to a position where we can drop the appeal is a very, very good discussion. But we can't do that without that significant financial investment to repair the harm that's been caused, and a significant financial investment to deal with long-term reform. And that can only be done by having talks. There are many parties to this. This has the potential to be messy, but messy is good. That's where we figure things out and come to one mind as to how to move forward and what classes deserve what level of compensation. And that's not something that the federal government of Canada can decide alone. If it were a different scenario, or perhaps under a different government, you would take adversarial positions and you would spend the next 30 days or whatever the appeal period is to file motions doing lawyer against lawyer. And now we are committing and continue to commit resources from Indigenous Services Canada so we can sit down with Dr. Blackstock, with Counsel to Mishoom and the Assembly of First Nations and others to come to a solution which is based on the best interests of the parties involved, and that is getting quick, expeditious payment and a process by which that is done that does not re-traumatize people. And key to this, the long-term reform package, which Dr. Blackstock has been advocating for so long. So this is an opportunity for a fresh start. I do not want to presume the outcome of this, Christy, because it is so key to allow us to have that space, and putting the appeal on pause allows us to focus efforts not on taking adversarial positions, but rather to be talking to each other about where we can find some commonality. And if we can drop the appeal altogether, that would be great. If we can winnow it down to the elements that perhaps we have some remaining disagreement on, well, that means that people that we don't have any disagreement with about their compensation levels and package, including those that may get over $40,000, we can move quickly and expeditiously on making sure they get compensation. Oui, j'essaie de souvenir ce que j'ai dit en anglais et de traduire en toutes lettres, Louis. Ce qu'on espère, c'est vraiment à tête reposée de pouvoir s'asseoir au lieu de prendre des positions qui sont adverses dans un système judiciaire qui est noir sur blanc. et d'en venir à une solution qui est pratique vers une juste compensation envers les enfants qui ont subi ce tort et ce préjudice et les personnes qui ont été affectées, ainsi que d'y aller avec l'application et ce qu'on veut atteindre sur la réforme à long terme sur le système de services à l'enfance qui est toujours et qui reste encore brisé. Au lieu de passer notre temps à préparer des soumissions juridiques et des positions, l'effort sera mis sur la concertation avec le personnel de Services aux Autochtones Canada, Dr Blackstock et son personnel, ainsi que l'APN et toutes les parties qui sont concernées, pour en venir à une solution qui est pratique, vraiment réduire les points de désaccord, quitte à en venir, peut-être à lâcher l'appel, ou vraiment à pouvoir, dans le pire des cas, avoir un appel qui est vraiment limité au point où on reste toujours en désaccord. Mais je ne veux pas présumer ici aujourd'hui l'issue de ces discussions. Il faut les avoir. Et c'est quand même, comme Mme Kirkup l'a dit, une période de temps assez restreinte.
Can I just perhaps try to summarize slightly differently, Kirsty? We're here putting the appeal on ice, so putting it in abeyance precisely because we think we can arrive at a solution that's comprehensive and global, that includes not only what the CHRT was trying to do, but also touches the 2 and now 3 class actions, as well as putting the long-term reform in place. We're here because we think we can do that in a short period of time. We've got the goodwill of the parties. We've put a significant amount on the table to get the parties to the table, and we're confident that this can happen. If we just try to implement the CHRT decision through the framework agreement, we think that would actually take longer at the end of the day, and there would still be litigation or disagreements over that. So we're putting everything on the negotiations in the room, which obviously we're going to keep confidential, and we're pretty confident that we can do that.
Christy, do you have a follow-up?
Yes, I do. So just to confirm then, the parties in the separate class actions are also going to be involved in these talks, and in theory, you're looking at what you describe as a significant financial settlement that would essentially resolve the CHRT case and the class actions all in one foul swoop?
That was the intention of the offer, Christy. Yes, absolutely.
Operator, next question.
Thank you. Merci. The next question is from Dylan Robertson from Winnipeg Free Press. Please go ahead.
Hi, thanks for taking our questions, Ministers. The Prime Minister said this month that the government was consulting groups about this case. Just a week ago, Ms. Blackstock said that she had no clue who that included. So could you please specify who outside of the parties to the case your government was consulting with, and when did that outside consultation start?
Yeah, thanks, Dylan. I simply think this was a reference to the mediation process. We certainly have been in talks with the parties over the last week or so. They've been very intense, but the Prime Minister, I believe, was simply referring to the mediation process.
Dylan, do you have a follow-up?
Right, okay. That doesn't quite explain Ms. Blackstock's comments, but I'll follow up here. I'm wondering how confident you are that you can actually sort out the question around the scope of the tribunal in 2 months, just given how long this has gone on. I mean, surely even during the caretaker period, this could have been advanced by government lawyers.
Well, maybe I can start and then turn to Minister Miller. That's okay. It's hard to see, Mark, whether or not you're reaching for your microphone. I think my conversations, and I'm new to this team, as you know, and new to these conversations in some of the parties, not all of them, because I do come from Northern Ontario, and of course, I do know Grand Chief Archibald from previous work. But I will say that the conversations I had with the parties this week indicated to me that everybody is extremely serious and extremely I would say, cautiously optimistic about the ability to find a path forward, especially with the seriousness of the government's significant offer. This is no doubt going to be a very intensive piece of work, but there are, I think, no qualms by any of the parties that it needs to be done as quickly as possible for Indigenous, for First Nations children, and for the people that are survivors of the discrimination and systemic racism. So my sense is that all parties, including the Government of Canada, are extremely committed to doing everything it takes, as I said earlier, to reach that global resolution. And I anticipate that after years of hard work, another couple of months of extremely hard work doesn't daunt anybody.
And Dylan, simply, during the caretaker period, even leading up to the elections, there were talks that were ongoing. They did not lead to the conclusion that we had hoped, but we are in a much better position today, particularly in light of being able to look at a global offer as well as long-term reform.
Operator, next question.
Thank you. Merci. Our next question is from Ian Kaufman from Dougal Media. Please go ahead.
Hi, thanks for taking my question. My question is for Minister Hajdu, and she talked about the process of rebuilding trust with First Nations and Indigenous communities. I don't think anybody could argue that filing this notice of appeal has set that process back, regardless of the intentions. And I just want to ask her if she truly believes that damage to the relationships is worth it to continue this appeal.
Well, thanks, Ian, and it's also nice to hear your voice from my own hometown. I'll just say what gives me comfort is that this is an agreed upon approach by all the parties. There has to be trust in order to agree to this approach. And even though it is fledgling, I will say that it's positive. As I mentioned, I have spoken to the parties and I have a deep respect for the work that they have been doing. But there is an optimism that the government is extremely serious about ending discrimination and compensating people who've been harmed. And there is an eagerness to get started. So I will say that this is a very, very important piece of that rebuilding of trust. And I am, again, grateful to the parties for coming to this table of negotiation with us. And I look forward to what we can achieve together.
Thank you. Do you have a follow-up?
Yeah, for Minister Miller, I believe at the beginning of this presser, I heard him say that there's no intention to reduce any amount paid from the order amount, and I'm just wondering if he can confirm that, or if perhaps I misheard or he misspoke.
No, we need to let this process occur between the parties involved. I simply said, and I believe it to be true, that there is no intention to reduce the amounts to be paid to the children that have been removed from their families. And in fact, increased it above 40,000 in some cases.
We'll now turn back to the room for questions. Go ahead.
So, hi there. Yeah, it's Fraser from UPTN National News. So, maybe I'm just missing something here, but I think that the Canadian Human Rights Tribunal decision is actually fairly clear. It sets some parameters, and it has a group of children that are covered in their families, and it's pretty clear in the parameters. So that there's nothing there that's stopping you from working on the child welfare system as a whole that needs a lot of restructuring, obviously, and you know that. And you could be working on that today, tomorrow, or you could have been working on it since you got elected. I'm sure officials have been. It's a complex thing. So those are two separate issues, I think. And the other thing is, I guess you are calling this it's an appeal. It's not a soft appeal, and you're saying you don't want to be adversarial, but you've now gone to court twice. That's adversarial. There's no, you're lawyers, you know that there isn't degrees of adversarial. So you obviously are doing that. So, why don't, and I mean, Minister, to be quite frank, you referenced another government. Yes, you're right. They would, if it was a Conservative government, they would put out a number that they thought was reasonable, and they would probably. But what you're doing is you're appealing. You're not saying why you're appealing. You're saying you're not giving. You say you don't think the Canadian Human Rights Tribunal should have jurisdiction, but you won't say who should. Surely not you. I mean, you have a bias. You're not the ultimate arbiter of all this, and so. And we're here at 6 o'clock, or even 6:30 now on a Friday night. Surely you weren't negotiating, this morning. It's a calculated move, obviously, to bury this in the news cycle. So how did you expect anyone to take you seriously on this, honestly?
Well, maybe I can start and then turn to Marc. There are a lot of assumptions in that question. Indeed, we have been negotiating and talking to the parties up till and including today. Trust does take time to build. This is an appeal with a pause on any litigation to allow that space and time for the parties who have agreed, by the way, all of them, to come to the table to find a way forward, to respect the ruling of the CHRT, but to do it properly in a way that gets money to people who need to be financially compensated, does so in a way that is trauma-informed and respectful of the ideas of the litigants and the parties, if you will, who are experts at designing these kinds of systems, and importantly, how that system of reform should unfold. I think this is really, really important, that this is all of the parties sitting together, all of the parties agreeing to a stay of the appeal, all of the parties agreeing to begin those talks Monday morning and to work extremely hard to get this work done for First Nations children.
Yeah, look, I obviously by your question, there won't be much convincing you, but I'm sure you'll do a great job in making sure this doesn't get buried, and I'm sure David behind you won't either, and Christy, who asked the question, and Mackenzie and Stephanie, you've done excellent jobs in doing in covering this issue. It is one of national interest, and we're sitting in the National Press Theatre in front of all Canadians and Indigenous peoples to discuss this. It is not accurate to say that there was nothing going on this morning. I know it. You can see the bags under my eyes. These were negotiations up to the last minute and discussions up to the last minute. We need these parties at the table to move forward on long-term reform. Like you said, this isn't the federal government deciding. And admittedly, throughout all this, you've seen that there's very little under our control. We're here with open hearts, open hands, and saying, work with us to work on long-term reform. We've tried to do long-term reform or even reform on our own. It's failed. We're doing it with parties involved, with the IFSD studies to support it, and we're prepared to move forward with a significant financial package to back that up. And frankly, for any government that would purport to replace us, make this irreversible, because this is about the future of our country. Indigenous peoples know it well, and people like me, or that have even a that are looking at this and are tuning into this. This is about being able to look at your own children in the morning. It's about being able to look in the mirror. So it's very important to who we are as a government, but it's also very important to who we are as a country, and we're very serious about this. We're very serious about sitting down. And yes, we did reference a previous government, but frankly, everyone's to blame. And we need to be able to be mature enough to say that and say we're putting this on pause. We do have challenges with the CHRT order. We could implement it tomorrow, and we wouldn't fix long-term reform. We wouldn't compensate those who are the most egregiously hurt by this. We want to work with the councils in question to come up with a comprehensive way to compensate the same children that are being covered by 3 or 4 sets of legal counsel. That is not unproblematic, and at least you do need to recognize that. I get the point, and we're very emphatic about moving forward with the parties, and that's why we put something in front. I won't presume the outcome, because I think it's very important for us to have those discussions in a situation where we're not actually drafting legal arguments to oppose each other. And I'd get people who are frustrated with the appeal. I am too, David is too, and so is Patty. It isn't the position that we want to be in, and certainly it doesn't help with reconciliation. But we're doing something that we think is right. It'll be an equitable and fair way to address this, but it isn't decided solely by the federal government. That's why we're sitting down and going to have those discussions over the next 2 months.
Yeah, well, thanks for that. And I mean, I don't feel like to defend my organization, but I work at we talk to Indigenous people all the time, and these assumptions are based on what people have been telling us long before I was there for years. Not just your government, the previous government, that's true, that governments have a fixed set of rules. They say they don't want to litigate, but in the end they end up in courts, and they're adversarial, right? So I get this issue has been going on for long before your government was around. It sadly will probably be going on long after your government isn't around. It's a very complex issue. So I guess with this ruling, it came down. You decided to take it to court, not the other party, your government. And then you decided to appeal it. And now, so what motivation would the parties, they've already been fighting this long before you're around, and they don't really have a lot of trust in any government. What would be their motivation to settle this when they basically got a judgment that clearly agreed with the Human Rights Tribunal decision, and you clearly don't agree with it, but you won't say exactly why. You say you won't give numbers. You'll say it might be more, it might be less, or so it. You're talking about long-term reform. So I guess why would you think that the parties would be motivated to settle this when it's just another government fighting them in courts? And they're doing pretty well on the decision right now. So why would they be motivated to settle it out of court?
Because they have an opportunity to make a difference and be at the table on long-term reform. And I don't blame them for not trusting those. I don't blame them one bit. But they're there. We've opened up the ability. We're saying to them, we're not deciding from on high anymore. We'll sit down. There's a significant package on the table, and frankly, it's something for the time being. And I get that people are entitled to answers, but we need to keep out of the public eye in respect of the parties in question.
And I'll just say, I'll add to that and just say that it's been very clear in my conversations and work in the short time that I've been now the Indigenous Services Minister, that there is a sole motivation. And the sole motivation is to do right by Indigenous children and people who've been harmed by this system. And I think what I got a sense from the parties as we worked through this last very hectic and very busy days for all the parties was a deep desire to get that work done and a beginning of a hopefulness that they're working with a government that understands that solutions have to be designed by and with First Nations people, and that they and that they have an opportunity to work with a government that deeply understands that and has put forward a significant package to be able to achieve those goals.
Wonderful. Next question.
Hi, Ministers. David Thornton, CBC News. Obviously, there's a gulf between you and the other parties involved. Otherwise, Cindy Blackstock would be on the stage with you. So can you tell us how far apart you all are in negotiations?
No, not really. I think we need to have that discussion in private. Certainly, we've bridged a gap over the last little while by making that offer. Otherwise, we wouldn't be in a situation where we're. I don't like the imagery, but I despise the imagery, but we're putting our swords down, and that's something I believe we recognize by AFN and Dr. Blackstock. I don't want to put words in their mouth, but the trust is thin. We know that, but they are willing to extend it for a certain period of time and work with us on fixing the system. And it was mentioned in the previous question that the CHRT order can be implemented, but it does touch on long-term reform, on major capital, and we want to work with the parties on that. We need major investments into communities to make sure that again, the system that's being underinvested in is fixed, and we need their work, we need their advocacy, and we frankly need them to hold us to account. Again, I can't guarantee success on this, but I can guarantee you we'll do our utmost, and we're willing to fail trying, and that is the reality of it. I don't want, again, none of us on the stage or Minister Hajdu want to be in an appeal position. So we're going to work like hell during the next 60 days. Patty?
I'm just curious, like, it sounds like you're trying to do a lot of things here. But why not just comply with that ruling, compensate these children, and then figure out how to do all the other things that you want to do, and the people that are left out, address that as well. But you can do something today. Why not just get it done and then figure out how to do all the other stuff you need to do?
Mr. Hajdu, do you want to?
Well, thank you. Well, thanks, David. And I'll say this, and I've answered this already, but I'll answer it again because I think it's so important. We want to work with the parties to make sure that we get to the end goal, which is to compensate people who have been harmed and to create a better system, an equitable system, a compassionate system, so that no more harm is done. And I will say that the government of Canada doesn't necessarily have the expertise to be able to do that alone. And that's no disrespect to the many hardworking public servants that I know are scattered across the country trying their absolute hardest. But it is actually with the expertise of Dr. Blackstock and the AFN and the other parties that we will get to a place where we are able to achieve those goals without re-traumatizing individuals and in a way that is appropriate and designed to end this discrimination once and for all.
But that takes longer, right? Like what you're proposing could just...
Well, no, we've actually agreed that we've always, from the get-go, said that any of these cases, to the extent we have any respectful disagreements with, we're prepared to expedite the decisions on them. And that's something that has actually moved fast in this case, and will continue on that path. But I don't want to presume the outcome. Again, this is highly complex, but there's a very simple scenario where you could very well have one child that's covered by the compensation order, a child that, because of 1 day prior being in care, is not compensated by the order, could presumably get less. That same child who was compensated by the order is only up to $40,000 and then has to go through a class. So that's why we need everyone at the table, David, is because we have to have that discussion as to how this articulation of a framework would do. From the date in 2019 when the Prime Minister stood up and said there's been discrimination, we're going to compensate these children, 2 class actions were filed. At the same time, I made sure that Dr. Gideon, who's been working within our department with Dr. Blackstock at the negotiation table, along with lawyers, was sitting down coming up with a framework that is close to 200 pages so we can proceed to compensate children in an expedited fashion and not re-traumatize them. We know there's documented evidence of this compensation process re-traumatizing people, and we are dealing with a younger class of people. So if you're asking the same child to go through 3 processes to get compensated, there's a real risk there. And so those are all discussions that we're going to have. We've had them to some extent before. But now we can come together with one mind, plus with long-term reform, which is so key, so that we're not back here in 5 years trying to continue to fix a broken system. It's important, it's significant, it represents significant investments on behalf of the government of Canada, but we're being mature and we're going to sit around the table and hash this out.
David, in addition to what Marc said, just also in terms of fairness and timeliness, so we feel that by doing this we can get it done faster, but we can also achieve a measure of finality to this. If you leave other pieces, they keep going, they keep going, they keep going. We think by getting everybody around the table, by putting a significant offer at the table, by addressing everyone touched by this, and by addressing how we plan to fix it so that we're not here again, we achieve a measure of finality. And that's important for both Indigenous and non-Indigenous peoples, because we need to move on the reconciliation process. We need to move forward. And this is a way to get everybody moving forward. And I think the fact that everybody has agreed to try this is significant.
Thank you. That ends our press conference. Have a nice evening.
Thank you. Merci.